We have a quorum? Yes. Ladies and gentlemen, pursuant to the public comment in accordance with Title Section 1.2, 1.7 of the Code of Ordinances, all items on this agenda, which are one, are open for public comment. If you would fill out a speaker card and place them in the designated location. When I announce the item, you will be called on to speak and given an allotted amount of time by the Mayor Pro Tem. If you do not wish to speak and wish to be noted as a record in favor or opposed to the agenda item, please also fill out the card. Item A, conducting a hearing to consider removing Mayor Roper as a parish attorney for the grounds as provided in notice in accordance with sections 2.13 of the Plan of Government and Resolution 50827, adopted May 14, 2014. This matter may be discussed in executive session by council members Welch, Delgado, and Amoroso. Ladies and gentlemen, this is a public hearing. I have 4 speaker cards. If you are going to be a witness on behalf of Ms. Roper, I will call you at that time. But if you are here as a citizen wishing to speak on this item, I would open the public hearing and allow comments. Seeing none, I'll close it. Yes, ma'am.
Can I put out a card to speak?
Okay, are you here to speak on behalf of Ms. Roper?
Yes,
Okay, would you like to do it now or during her allocated period?
whenever y'all want.
Ms. Roper's been allocated under 30 minutes
Ma'am, would you like to speak now?
to present her case. I think she needs to be explained that if she speaks during Ms. Roper's case, and that takes time for Ms. Roper to present her case. I think if she wants to speak in a public forum, it does not take away from Ms. Roper's time to present her case.
Take it away. Ma'am, would you like to speak now?
If it doesn't take away from Ms. Roper's time.
Come on up. Are you Miss, is it Reeves?
I'm Ms. Manship.
I'm sorry.
Ms. Reeves. I would like to speak in the public forum too, if possible. sir.
Sure. If you would just, I have 4 speaker cards. Mr. Newkirk, Myers, Manship. We'll go with Miss Manship first, obviously. And the last one I can't make out is Miss Reeves.
Yes. Bring it.
Okay, go ahead, ma'am.
Before you start, I want to have the official hearing in session as of right now,
Yes, ma'am.
because I wanted to make a motion for a 30-day deferral, because I haven't had an opportunity to consult with our council.
Motion by Councilwoman Banks Daniels for a 30-day deferral. Is there a
Not
second?
30 days, 30 minutes.
You want
30 minutes.
30-minute deferral? The meeting was noticed at 2 o'clock. I'm not sure that we would comply with the public notice provisions. Is there a second to that motion? Seeing none, the motion dies. Yes, ma'am.
My name is Carol Manship. Let me say at the outset that I know Mary both personally and professionally, as I used to work as a legislative assistant. I think what is happening here is appalling. I think that the council is acting irresponsibly, and I am horrified that this woman's reputation has been maligned in the way that it has been. My councilman in particular, John Delgado, has pursued a rather vicious, I think, attack on Ms. Roper. And it's completely unwarranted in my opinion. Her integrity has been attacked, her honesty, her scruples, her ethics, and for no apparent reason other than the machinations of some council members. I think it's a sad day for the city of Baton Rouge, the parish of East Baton Rouge, that this council would even consider this. There hasn't been anyone in the parish attorney's office who has devoted more of her time and effort to that office than Mary Roper. And what this council is thinking escapes me. And remember that what goes around comes around. When you do this, please consider how badly this reflects on you as council members and on the city of Baton Rouge.
Thank you, ma'am. Mr. Newkirk?
I'm Mr. Pete Newkirk. I live at 5840 or Land St. Francisville. I know most of y'all. I've been with the city for approximately 30 years. 20 of those years I've worked with Ms. Roper as the building official in Public Works, and then as the assistant director and director of Public Works. My dealings with her in the parish attorney's office has been stellar. Whenever we have legal issues, we go to the parish attorney's office. I've found Mary directly on a few occasions. Mostly I go through her staff, but in my 20 years of dealing with Ms. Roper, I think she's very logical. She researches the cases very well. I really have no disappointments or any criticisms with her or the way she's run her office. I'm speaking from the outside of an agency that uses the office. Obviously, y'all have more intimate knowledge of her and some of the things she's alleged to do. All I can say from my perspective is a user agent of her department, as she's been with the parish, as she's been with being the parish attorney. I think she's done a stellar job from a public works point of view. There's things we couldn't have done without her and her support. So whatever the vote goes, I'm sorry to say, I would hate to see her go. I think she's an asset to the community and the city parish. And I'm just saying, as far as I'm concerned, she's done a stellar job for us in our department. Thank you.
Thank you, Pete. Good to see you again. Mr. Myers?
Hello to everybody again. I saw y'all a few weeks ago. Good to see you again. I'm just coming today not to tell you what to do or suggest anything for you to do, other than one thing, and that is to do the right thing. Whatever it is that you, in your heart, feel is the right thing to do is what you need to do. I'm giving you my perspective as the council administrator treasurer for many years. Worked with Mary very closely before she was parish attorney and after she was parish attorney. To say that she's done a good job, I think would be an understatement from my perspective. She was always very responsive, very helpful to me. As you know, I served as your CAO, as Casey does now, so she quasi-reported to me and worked through me. Same thing with Wade, same thing with Mike Ponder before. She fits that mold. I don't know all the ins and outs of what's going on. I do know that as far as me dealing with her, we may have disagreed about things from time to time, but things we always work out, and I always respected her opinion and her ability. So I hope you take those things into account. And again, I just urge you just to look at yourself, look deep within yourself, and just do the right thing. Whatever the Lord leads you to do is the right thing. That's what I would ask. Thank you for the time.
Thank you, Brian. Mr. Reeves, I'm sorry. What is your first name?
Jan Reeves,
Okay.
President of the Baton Rouge Association of Women Attorneys. The Baton Rouge Association of Women Attorneys, for those of you who do not know, was formed in 1978 because of gender inequality in the laws, such as abolishment of the old head-master rule. We moved in, and our current vice president served on the 50 States project that rewrote the laws of the state of Louisiana to be gender equal. And in the 1990s, the members of our group were formed along with other members of the state on the Supreme Court Commission for Gender Inequality in Courts. I have served the last 5 years as president's organization. I was president in the 90s. since the laws are now much more gender equal, occasionally issues of gender bias are brought to this organization. And I hate to advise, I have never received a flurry of calls as I received when this matter was scheduled for hearing against Mary Roper. Of the many members that called me, it was suggested that she was not part of the good old boy network, that she would not be treated like this if she was a male attorney. We've had some very distinguished parish attorneys who were male in front of her, for instance, the Honorable Mike Ponder and Wade Shows and many others. Mary was the first person to rise through the ranks, the first female parish attorney. She is a respected member of this community. I've known her for 20 years. She has served in various community capacities from the Inns of Court and been very active in the legal community. I don't want to repeat all the comments I heard. I think you all would be shocked at the perceptions, except to report to you it is a widespread perception, widespread, that this is not fair, that there might be underlying gender issues, which I can't put on evidence of that. I'm just telling you the perception that I have received. From my personal knowledge, I can advise that Mary Roper is very competent, and I'm up in courts all the time. I see her parish attorneys at work. I see what they do. Her ethics are beyond reproach. She does not hand out contracts to people who are simply friends of the council. She follows the process. She does the bidding, etc. So overall, I would ask for those of you who are undecided, because I expect that some of you are decided, but for those of you who are undecided and still looking at the issue, that there are many in this community who consider this a setback. There are many in this community who do not want to roll back into the 1980s and start all over again. I would suggest that you look at this very seriously and understand that the repercussions are far further than this council room, and hope that you make the right decision. Thank you.
At this time, council members, you should have a white binder with the procedures outlined for this hearing. Each attorney, Mr. Shows and Mr. Foster, will be given 5 minutes to make an opening statement. The council will then have 30 minutes to present its case. Ms. Roper will have 30 minutes to rebut those allegations, and then Mr. Shows and Mr. Murphy will close with a 5-minute closing. At this time, I'd like to recognize Mr. Foster.
I understand that Mr. Foster has given certain information to the council. I'd like to have the opportunity to give information to the council also. I don't know when it was given. I don't know how long they've had an opportunity to look at it. It seems to me that the procedure is flawed, that they may have had their documents from the prosecutor and had an opportunity to review that.
Thank you,
I
Mr.
haven't put that in
Shows.
mind yet.
Thank you. You'll be given 5 minutes after him if you have some information.
Can I present my documents, Mr. Luke?
You'll have 5 minutes after Mr. Murphy. I recognized him to speak. Thank you, sir. Mr. Foster.
Representative members of the council, Murphy Foster. First of all, let me just briefly address Wayne's comments. The binder that you have, the collection of documents that were given to Wade, actually a couple of months ago, given to him again on August the 25th. And he's got all of those documents. You've seen all of those documents as well. You've had those documents that were collected by Mr. Whitehead earlier in this process, taking that back to me. Pursuant to the plan of government, Casey Cascio, the council administrator, directed to Mary Roper on May 15th official notice of the hearing that would be held during the termination or continued employment. That notice set the hearing for May 28th, 3 o'clock. She was advised that she'd have the opportunity to be heard, and that at her option, the hearing would be either public or private. And now that she opted for a public hearing, she was specifically advised on the grounds on which her termination would be considered, those being improper disclosure of proprietary information, breach of fiduciary duty, failure in competence. In addition to that, on August the 29th, a letter to Mr. Shows from me, the exhibit number 2 of Mr. Shows exhibits the 3 additional reasons that came about after she filed the lawsuit. First of all, the additional reasons were breach of ethical conduct, stemming from the fact that she sued her client, you, that she noticed the deposition and subpoenaed a number of you to be deposed, and 3, specifically that she proposed, threatened to release proprietary information that was privileged between council members and herself as the attorney. And finally, the last item was that the delay in proceeding with diligence to obtain a copyright for the MoSEP software. Those are the basic grounds. Let me just address each one of them briefly. Number 1, that is that she distributed software of the city parish to third parties without authority. That is proprietary, was and is proprietary information. She provided it, 1, to Mr. Ian O'Day, her husband, who, by the way, is not just her husband and not just a employee of the city parish. Mr. O'Day, whether you know it or not, owns 3 separate, or is either, according to the Secretary of State, manager, member, or agent for service of process of 3 separate and independent software companies whose business it is to sell and market software. She provided that information to him. That information, which included the source codes for this proprietary software, also became a matter of headlines shortly thereafter, during which time an employee of MoSEP was accused of marketing and distributing proprietary software. That matter became a matter of a criminal investigation. Whether or not her husband, Mr. O'Day, was involved in that is not an issue. It's not being alleged specifically. But the judgment and the question of whether or not that should have been supplied to other people is certainly on the table, as is the fact that she's now admitted giving it to a company called Evoke for analysis as well, without authority or permission. Finally, a suggestion that this software code, which she disclosed was a public record, is just wrong. Specifically, there is no doubt the software code in question is absolutely proprietary and not a public record. Louisiana Revised Statute 44(1)(a)(2)(b) says, notwithstanding subparagraph A, which says what is a public record, says any documentation, material, security feature of a public body's electronic data processing system, information technology system, telecommunications network, or electronic security system, including hardware or software, security password, or security procedures, process configuration software, and code is not a public record. There can be no doubt that she distributed proprietary, non-public software to people that did not have the authority to receive it. The other matters, as I've mentioned to you, have to do with a loss of confidence, fiduciary duty, which both in some parts relate to this. There's also an issue of whether or not she properly administered her duties as parish attorney by properly utilizing managerial and professional software, time management, failure to properly manage the office. Parish attorney's office has $7.3 million in a budget. That's a lot of money to delegate to one person to be responsible for. There are certain questions regarding that have been raised regarding her management of that particular office as alleged. The unethical conduct, which has been mentioned, she sued you as the council. Lawyers, as I'm sure you probably read in Judge Caldwell's opinion, lawyers all have temporary judgments. We serve at the will and pleasure of our client. Our client no longer seeks to have us, no longer has trust in our judgment or abilities. They always have the right to terminate us, and that was the decision of the district judge when he dismissed her suit. Also, the Louisiana Rules of Professional Conduct that govern we as lawyers prohibits us from taking a position in conflict with our client. It is unprecedented that Ms. Roper would sue you, the client, demanding that she be allowed to remain your lawyer. Again, unprecedented. Threatening to release privileged communications between you as members of the council, her client, and herself is also alleged as being an ethical breach, in that we as lawyers aren't allowed to breach those particular privileges. And here it was threatened, she threatened to do just that. And finally, she failed to proceed with diligence with regard to applying for the copyright for MoSEP software. That process began in February 2008. It's not finally registered until June of 2011, 3.5-year process. And that is a summary of the complaints brought against Ms. Roper, and with my remarks at this time, I'll offer, finally introduce those white binders that you have, which include the documents that I mentioned earlier. Specifically, number one, letter from Casey Cashew dated May 15, 2014, Mary Roper advising her of the initial hearing. May 28. Number two, May 28, 2014, special meeting agenda. Number three, response to Roper's May 21st, 2014 request. Number four, in logo exhibits A-L. Response to Roper's May 21st, 2014 hearing request. Number five, Ms. Roper's pre-hearing brief that she's.
Thank you, Ms. Foster. Those will be accepted. Wade, I don't know if you noticed, but I gave him 8 minutes. Okay, I was just going to tell you. You have 8 minutes.
I'm really going to be like a good football coach. I have a game plan that I came with. I'm going to stick to the main game plan and not vary from it, although it's very problematic when somebody says we're going to have a certain procedure and it changes in the middle of the process. But I'll stick to my game plan. Ms. Roper has been employed from a law clerk all the way to the Parish Attorney's office for some 21 years. Her reputation is impeccable, her work ethic is impeccable, and after the decision today, you may find another attorney, you may hire another attorney, but you will never find a better attorney, and you'll never hire a better attorney. As I stand up here, I'd like to first of all, have everybody's undivided attention. This is a very serious matter. It's not just the loss of a job, it is the loss of a career, it's the loss of a reputation that no one can ever give back. And I know that y'all are going to be fair, but don't be persuaded by emotions from lawyers trying to give red herrings to you as to how you ought to decide. The main problem with Ms. Roper and his relationship with counsel is we got too many lawyers involved. We really, really do. We have lawyers from the outside wanting jobs. We have lawyers from the outside that have friends on this council. We have lawyers in the Parish Attorney's office. We have lawyers for the council. We have lawyers for each or some council members. We have a prosecutor. Ms. Roper has a lawyer. That's a whole lot of lawyers. And when a whole lot of lawyers get involved, it creates a tremendous problem, and it's a disaster fixing to happen. So what I would like to do is let's get, hopefully, back on an even plane with business people of the community that sit up here and work the business. And let's talk about making business decisions and not emotional decisions. There's nothing more inflammatory for a lawyer to say is, you got sued. Your lawyer sued you. That's not what happened. When we appeared before you, we asked for certain things before the council. We said, will you give us an appropriate procedure so that we can have a hearing? Can we have the appropriate rules for discovery? Can we do certain things to make sure that due process is set forth? And the answer was yes. And I never heard anybody object when Mr. Luke and Mr. Delgado committed to an appropriate procedure. That procedure is not defined in the plan of government as to how long it's going to be, How many witnesses are called? Can you cross-examine? What's the order? None of that's defined anywhere. So, that information, in spite of Mr. Luke and Mr. Delgado, and no objection from the council, that information wasn't furnished. We asked to outline what the procedure was going to be. That wasn't furnished. You know, every day we talk about crime in the streets, either our youth or adults in the street. And you know why? Because they do not have a mechanism to resolve disputes, or they're not comfortable with the mechanism in place to resolve disputes. They take their conflict to the streets. Ms. Roper elected to say, court, tell me what the appropriate procedure is. And it wasn't just Ms. Roper wanting the appropriate procedure. At that meeting, I heard some voices saying, what procedure are we using? It seems to me like we're judge, jury, and prosecutor. So what does Ms. Roper do? She says, court, I never sued anybody personally. Court, I'm suing the council. Give me some guidance as to what is appropriate for the council to do. And shame on her if she didn't take it to the street. But you ought to applaud her for at least doing it the right way, to say, court, give me some guidance. And that's what occurred. Don't let anybody inflame you by saying she sued you. Mr. Amoroso, you never got sued. Mr. Luke, you never got sued. Delgado never got sued. Ms. Marcel, nobody got sued. It was the council. The council gets sued every month over some issue. So don't let that inflame you to say somebody sued you and it's a violation of rules of professional conduct. It was the appropriate response to say, give me some guidance as to what needs to be done. And that's what she did. The procedure, if you remember, was set forth initially by Jack Whitehead, who told me what the procedure was going to be. I heard some council people say, we love you, Jack, but I don't know, we never hired you. I don't know, the council never voted on that procedure. Mr. Whitehead said what the procedure is going to be. At a hearing, I asked Mr. Delgado and Mr. Luke what the procedure could be, and they agreed what they thought an appropriate procedure, or parts of it might be. You know what happened when we went to court? Lawyers, too many lawyers involved. The lawyers say the council never voted on that procedure. Therefore, what Mr. Luke and Mr. Delgado said did not bind the council. Nobody said judge. The council members agreed to that. Lawyers getting involved, looking for ways to say that the council never agreed to it. But now on, I want to make sure when I get a commitment from certain people that there are going to be votes to make sure they have the appropriate authority. And that's what one thing that's problematic. Now we're here with a procedure that starts out, Mr. Murphy Foster says, I have 5 minutes, I prepare for 5 minutes, he gets 8 because he needs a longer period of time. That's not fair. So we have a procedure. Did y'all vote on that procedure? Or does the prosecutor get to tell me what the procedure is? The prosecutor gets to tell me what the procedure is. The council didn't agree to that procedure. So here we are with a procedure mandated by the prosecutor. Y'all think that's fair? There are a lot of charges that have been instituted by Ms. Roper, starting with Mr. Whitehead's charges. Subsequently, they've been amended. Less than 10 working days, Ms. Roper has been alleged to have committed certain other violations for the first time. Less than 10 business days to prepare for a career decision. Let's not the emotions get involved, and Ms. Roper is going to address each one of those concerns. Mr. Foster has gotten up here and told you what the case is. I would request that everybody just pause for a second and think about what we're about to do, and think about the big elephant in the room. And I can understand this completely. 10 of 12 council people were brand spanking new when Ms. Roper was appointed Parish Attorney at the last vote before the election for those 10 new council people. The last vote was by a council that y'all didn't have the ability to pick your own lawyer. And you shouldn't have to pick your own lawyer. There are elders that come before you that agree to do road projects, buildings, and you have to live with that. There's an institution called the Parish Attorney's Office. The elders that voted for her knew her much better than somebody that would have voted for somebody that was in office for a month or 2 months. Dr. Pat Culbertson knew her 12 years. Mr. Charles Kelly knew her 12 years. Former Mayor Pro Tem Mike Walker knew her that long. These people knew and undertook the appropriate person. Mary Roper, please listen to the evidence. Listen to the evidence, not argument. There's a difference between what's presented and what's presented under oath and what's presented as true evidence. And I know that you'll make the right decision. Ms. Roper I'll answer any questions now, but Ms. Roper is prepared at the appropriate time to address all concerns. Thank you.
Thank you, Wade. Ms. Foster? The next 30 minutes will be for council members. And Mr. Foster, if anyone has any questions or would like to make any statements, press your button to speak, please.
Ms. Blubaum reserved any additional rebuttal comments for the last 5 minutes summation.
All right, council members, anybody wish to speak?
May I hand out my information now before we start? You said I was using it.
Sure, Wade. Well, wait, hold on. I'm represented by counsel, Mr. Foster. Can you give it to him?
He's that guy. And what hand you hand it out?
No, I don't care who hands it out. I didn't know if he had seen it.
I did.
Okay, do you have a problem with this?
No.
See no one else wishing to speak, I wish to speak. In 2008, I was elected as a council member. Having practiced law for 20 years, I had never met Ms. Roper on any occasion. At the time of our orientation was the first time I met her, and we had a good working relationship. Approximately 6 months into our first term, 2 news articles appeared on Ms. Roper's office. The first one was done by Mr. Jim Shannon of Channel 9 News. It was entitled, "Goodbye DWI." I didn't know anything about the city prosecutor's office at the time, so I asked questions. Mr. Shannon alleged that there were 3,000 to 5,000 backlogged DWI cases in the city prosecutor's office that were going to be dismissed because of failure to prosecute. This office falls under Ms. Roper's purview. When I asked Ms. Roper, specifically Ms. Roper, for the list of cases, she could not provide it to me. It appeared that Mr. Shannon had obtained it through the clerk of court of city court. Our city prosecutor did not have a list of outstanding DWI cases that had not been prosecuted. To me as a lawyer, I saw this as a real problem. Those cases are still there. They're still being dismissed for not being prosecuted. If you think that that is okay, we respectfully disagree. The second report came out. The chief prosecutor for the same office was indicted, found guilty, and sentenced to federal prison for fixing city court cases for money. This is Ms. Roper's office. This was in 2009. I again asked questions. Nobody seemed to know anything. As a lawyer, not receiving answers to my questions, I performed an audit. The audit was based upon my own independent research, but also on information I received directly from Ms. Roper's employees, her office. The number one complaint was that Ms. Roper was never there. I found this hard to believe. I thought all city parish employees clocked in or kept some form of time records. I was wrong. The city parish office does not have time records, does not clock in, and in fact keeps no record of when they're there or not there. I subpoenaed all parish attorneys, including Ms. Roper's, parking cards for the garage as a way to find out who attends work and who doesn't. That was the only method I have of determining who came to work or not. It showed Ms. Roper worked on an average week from 10:30 to 2. If you don't believe that's a problem for a full-time employee, we respectfully disagree. I asked for changes in 2009 to the office, some kind of timekeeping method, some kind of accountability. I asked that the executive leave policy be rescinded for that office so people couldn't use that as an excuse not to work. I was denied. We're not going to do it. The administration has now canceled executive leave policy. The mayor did that. Ms. Roper's office would not agree to do it. I have an inherent problem with somebody that is paid as a full-time employee that does not work full-time. It does not even really work part-time. So I kept looking. Ms. Roper has an active individual practice on the side with an office on Main Street. She also has a separate contract with the Louisiana Appellate Project where she's paid to represent approximately 40 criminal defendants every year and paid handsomely, $50,000 to $60,000. This is in addition to her compensation and benefits that we provide her as a full-time employee. I have a problem with that. If you don't, again, we respectfully disagree. I moved on with my life in 2010. Ms. Roper and I enjoyed a very good working relationship until the software issue. And unfortunately, I also was taped in a conversation I had with Ms. Roper wherein I discussed personal issues regarding my family, my child's health, and his condition, and other issues that are very personal to me. I was upset at being taped covertly. If you think this is proper and was okay, I respectfully disagree. I was also upset to find out that Ms. Roper had played this personal tape to employees in the Parish Attorney's office without my knowledge. I have a problem with that. And you just heard Mr. Shows speak for 8 minutes. And I know Wade Shows. I like Wade Shows. I practice law with Wade Shows. But he didn't at once address any of the issues that I have a problem with, that we may respectfully agree to disagree. Not one of them. But he said something in his memo that really caught my attention last night. And that is, all these things I've just laid out to you that I believe are problems, I can't point to one instance where her lack of supervision or failing to work full-time or failing to monitor what her attorneys were doing has caused any actual problem. That's what you said in your memo. I can't point to any particular incidents. But you know I can. And you know the incidences. So let's talk just about a couple, the last 6 months. One of the parish attorneys released all of the police records of a pending homicide investigation to opposing counsel for a first-degree murder case. That's a problem when first-degree murder cases are jeopardized because of a mistake made in the parish attorney's office. That's a specific incident. That happened 4 months ago. And we've been sued in that case by that defendant. Go figure. We were also sued and went to trial a month and a half ago in a civil case. The parish attorney that represented you, the taxpayers, did not present a defense. He did not call a witness or introduce an exhibit. As a result, the city of Baton Rouge is responsible for $550,000. That's a specific incident. In the last 6 months. If you think that's okay, I respectfully disagree. I have met with 4 of the city prosecutors, 4, who have done nothing but complain to me about the way the office is run. I'm tired of getting the complaints. I have envelopes on my desk that are labeled stamped confidential that people drop off, complaining about the way she runs her office. This isn't about her being a woman or a lawyer. This is about somebody to run the office as it should be run, by a person that devotes full time to the criminal, to the civil, to the ABC board, and to the administration. And Ms. Roper has not done that. With regards to the software issue, I did my own investigation, as I told Mary I would do. Her excuse for giving the software to her husband, who has a software business on the side, and sending it to her home email address, was that she needed him to parse the modules to be represented and sent to the Copyright Patent Office. She did this the night before and emailed it the next morning. So our IT department pulled up for me the screenshot of what she sent to herself and her husband at her home address. And it's the same thing that she emailed the next morning. There were no changes made to it. If she needed her husband's expertise, there was a means to do that. There was a way to do that. She didn't do that. And she would not have been caught had another employee tried to sell us our own software. That's correct. This software that Ms. Roper distributed, a company approached the city parish and asked us to buy it back for $500,000. I think that's a problem. I have worked to find Ms. Roper a solution. I really have. Her lawyer can't deny that, and he won't deny it today. But she's refused every opportunity. And I didn't want to air all this in public. I didn't. But the only thing Ms. Roper says about me is it's political. That's all she ever says. She doesn't address any of this stuff that we've been talking about for 4 years. Not once. It's political. She's accused some of us on the council of wanting to give contracts to our friends. She's taken to Twitter. I don't have a Twitter account. I'm not going to sit up here and be Mayor Pro Tem and take shots in the paper and not tell you the real reason why Mary Roper, I think, should be replaced. It's real simple. She's not doing the job. Everything I've told you, I have documents, I have emails, I have records to back up. Be happy to show them to anybody. And with that, I unfortunately will move to remove Ms. Roper as Parish Attorney. Seconded by Councilman Delgado. Councilwoman Wicker.
Thank you, Councilman Luke. I just want to make a couple of comments. And I appreciate the long discussion and conversation that you just had, and I will tell you all that what you just heard, in my opinion, is one person's opinion. I understand that there may be facts and there may be documentation. I will tell you this, as a member of this council, who last time I checked, each and every one of us were elected to represent our respective districts and do our job as council members. I personally take offense to the fact that I haven't seen any of that documentation or any of that information. It has not been presented to me that anything has been done that would render the kind of action that we're taking. And I'm going to be real honest with you. I am very frustrated and embarrassed as a council that we're handling this situation this way. It has been handled wrong from the very beginning. The process has been handled wrong. I feel as a council member, I have been mishandled. And what I mean by that is that there have been decisions that have been made on my behalf, because the last time I checked, I ran for office just like every last one of us on this council. And I think that when you run for an office and you represent the people that you're called to represent, that you also have the right and the responsibility to be able to gather information or get information and respond to that information without other people making decisions for you. Because I have a constituency that I also have to answer to, most of which also have contacted me about supporting Mary in her role. I've had a long relationship with Mary, as I indicated before, way before I was on the council. I have never had any issues with her. And I just ask that whatever we do, that we be fair. If we have an issue with anything, any employee, I would ask that that information is presented. What we have tended to do on this council, in my opinion, is we'll have a conversation about an issue, and then there obviously are some backdoor conversations and discussions that are had and decisions that are made on behalf of this council without that information coming back before this council. And I have a real problem with that, because the last time that I checked, I work for the constituents of District 10 and for the city of Baton Rouge. And we all need to be respected with that. I don't know, there was conversation or information about Mary issuing stuff without permission and what happened there, and there was some criminal investigation. If there was a criminal investigation, what were the results? Was she found guilty? It looks like she's not in handcuffs to me. So I just need to figure out, was she found guilty or was she not found guilty on those particular issues, when we're making decisions as if she was found guilty. So I have a problem with that. The questions of mismanagement. We went point by point of all the things that she's been mismanaging and all of that. I don't remember or recall us as a council ever coming to a conclusion or a decision that she's mismanaging money, her staff is not working. As long as I can remember, all of the members of the parish attorney's office have other jobs. And so if that's no longer going to be the rule, then make that the rule for everybody. But don't single out Mary, because that has been the practice of that office since the parish attorney's office has been in existence. If we have a problem with that, then deal with that, but don't single out somebody that's been doing the same thing that, as stated before, every male or every other parish attorney before her has done. It wasn't a problem when those guys were doing it, so all of a sudden now it's a problem. But when you look at that, you're going to have to fire everybody in the parish attorney's office. And unless we're ready to do that, then I think we need to rethink the way that we're moving. There was conversations about complaints that were staying confidential, and we have complaints that are coming in. I haven't seen any of those complaints at all. The parish attorney that released criminal information, who was that? I haven't heard of that, don't know anything about that. I'd like to know who that person was, if that was actually done. And if we're going to do it for one person, I just think that we need to do it for all. And just in the words of my kids in Chandler, love you to death, but at the end of the day, you're not the boss of me. I need to be respected in a way that makes sure that when decisions are made on behalf of this council, that we have an opportunity to make a decision as a council and not one person's opinion, because it's very unfair for one person to take what seems to be a personal vendetta, and I did my own research, I did my own investigation, all of that is fine. I'm gonna tell y'all this, Wade said there are too many attorneys. I love all of y'all, but we are council members. We were voted to serve as council members, and I have a personal problem with attorneys on this council. If it's you, scream out. If not, be quiet. But I have a personal problem with attorneys on this council using this council as an opportunity to advance your personal careers because you got 5 minutes of television time where all of Baton Rouge can see the wonderful attorney you are. I have a problem with that, and I think it needs to stop. I move that we do not remove her. Thank you.
Motion to deny the removal by Councilwoman Wicker, seconded by Councilwoman Banks Daniels. Councilwoman, are you finished, sir?
Yeah.
Councilwoman Banks Daniels.
Thank you very much. It's been it's a very difficult time for me, especially when you get calls who question the entire Metro Council and its integrity and character. From day one, all of the questions that have come to being have been allegations as regards to our pro tem offering the job to someone in city parish that supposedly arranged airfare for his son. I didn't know him during that time. That hasn't been something that I have in any way addressed because it really didn't matter. What mattered is that we had the policy.
She did say that, yeah.
What? I don't understand.
Oh, you don't understand accusing me of
No, I did
something
not
improper
accuse you.
in a public
I did
forum?
not accuse you.
What part of that
I did
don't
not-
you understand?
What I said, Mr. Pro Tem, is that this began with phone calls that I received. That's all I said. And as I indicated, I don't know.
What's my son's name?
I think before you said, I said, I have no idea about any of that. I didn't know him, I wasn't on the council, and I haven't kept up with him. That is the information that came to me. Now, you've had an opportunity to share what personally happened to you.
Correct, but I did not say anything about
And I didn't
you
either. And what,
that involved my
Okay, point of
child.
order, y'all gotta, somebody has to manage control of the meeting.
I'll manage it right now.
it's not
and-
personal now. It's not
Councilwoman
personal
Banks
now.
Daniels,
It's not
I'm
personal
warning you,
now.
I will cut your time off if you mention any personal matters
You know,
about any council
and
members.
that's an example of what has occurred all these months. One person who feels that he doesn't have to respect the rights of anyone else. We all have suffered tragedy, and I'm one of them. And so this is not personal about you or your son. I am telling you what happened and how it happened.
Please don't mention my son's name.
I don't know his name, baby.
Just don't mention it.
I don't know
It's
him.
not a
I don't
hard
know him.
job.
I've never seen him.
Just don't talk about my family, please.
So anyway, that has what's come to me. I have tried to say, we are going to, as a council, handle this matter in a way that is professional, that has integrity. It is no way and I have tried to do that. I have asked questions, I have emailed, not only the entire council, the previous attorney, the current attorney, our pro tem, asking questions about the process, the procedure. What's fair? What are the allegations? What do we have? Are you putting us in a position for a lawsuit? One of the things that has said, that Chairman indicated is that he didn't get a response when he was in the same position. I personally could say I didn't get any of the responses. And so, as things go on, a lot of the issues that I have heard today, they're exactly what I experienced as this has gone on. Anytime an employee, if there have been indications that any employee has been inappropriate and it comes to one of us as a council member, we should have brought it to the rest of us and said, okay, this is what I have gotten, and let's see what we need to do. That has never occurred. I received anonymous letters and emails about a lot of department heads. I never even bring it up. I never even brought up. So this is not an isolated incident where a letter has come anonymously from employees who don't like the supervision of their department head. That has happened with numerous department heads, including, you know, the mayor, and nothing personal against the mayor, because everybody getting sensitive about stuff. But the different department, that has nothing to do with it. We can't keep that as something that we call somebody to lose their job over. The other thing, as it relates to executive leave, many of us are in a position on our personal jobs where we don't sign a timesheet. I don't sign a timesheet. But I know that I have to be there 40 hours a week. And I do that. And I think a lot of us, that's how it is. We have the executive leave policy that supposedly had been brought to the parish attorney. How can the parish attorney tell what y'all said that we're the bosses no to an executive leave policy? The next step would have been to have an ordinance, you know, put it on the agenda. We're going to do whatever with the executive leave policy as it relates to the parish attorney. We have that authority in the council. That's not something that we as the supervisors would go to our subordinates and say, can we do this? So that doesn't make sense to me. It's just made up. I don't recall the job where Mayor is working extra, but if I recall, it's a program to help persons who've been it's like an offenders program. It's to help people who've been falsely accused. Is that it? If I recall, I don't know if she can speak or not. But it's not like she's helping people get millions of dollars. It's to help people who may have been falsely accused of a crime to get their life back or to get the proper prosecution or, you know, thrown away or whatever. We have to work together and we have to be transparent, and it hasn't been transparent. That's all I've asked from day one. Tell me what we're doing. Even yesterday, you know, today I saw Mr. Foster, Mr. Murphy Foster, and then when we approved him as the council. I was one that approved it because I thought this was going to be an opportunity where I actually meet with him. He'll let me know what's going on. The one time, I've gotten 2 emails, if I recall. The first one, it was, and I'm not a lawyer, but I asked for a hard copy. It was 2 inches. It was 2 inches thick. It's the rubber band still on it. Then we received another one. I didn't dare ask for another hard copy of that one. So yesterday, I had a list of questions on the procedure today. I sent it 24 hours later. I haven't gotten a response from my attorney. I've never met her. I don't know what has been going on. I've indicated that I'm ill prepared. I've indicated that I don't know what's going on.
Ms. Banks, can you wrap it up?
Yes. In closing, Mary Roper hasn't done anything wrong. She hasn't done anything. The software issue, over and over again, we've had people say she did not do anything wrong, that have nothing to gain as it relates to this. It needs to change. We need to really, and I guess I kind of go back to with what our past chief administrator, we have to do what's right and not be so concerned about being politically correct, making deals, promises. We have to do what's right about people because it is going to come back and haunt us. And many of us on this council, we have other, you know, we are seen to have other roles and to move off this council into other roles, and the consequences that you have today for people who want to continue to serve in this level, we will be stuck with it. By removing Mayor Roper for what it is political, it is personal, and it might be because of a promised job to someone.
Thank you, Ms.
If we
Banks.
do that, let me just make this final statement, please. If we do that, we subject ourselves to a whole parish attorney where people are going to be scared to make decisions because they may lose their job. And the last thing is, I talked to a lot of parish attorney staff who were 100% for Mayor. Once Mayor was on administrative leave, then at that point, that's when things got kind of rocky. And they were afraid to lose their jobs. And they said, well, I have to do what I have to do to keep my job. And I just think that our attorney, our parish attorney, and their staff should not be in that kind of position.
Thank you,
And I hope that she'll be able to keep her job.
Councilwoman Marcel.
Wow. I actually had no intentions of speaking. I know that's probably shocking to some people. I just wanted to hear the evidence and make my final decision on what I was going to do. But a couple of things did jump out at me. They talked about and I met with Mary. She told me why she sent it to her husband and all of that. But as this thing went on, I had some real concerns when I started to, when you talk about people's jobs, when I started to get subpoenas at my private job for emails from my private employer. You can't get public records from a private place. That's what I've always thought. It continued. She stopped them, and then it went on again, and I got them again. So my employment that feed my family, not the $600 and some every 2 weeks that they pay me for this job, but the one where I pay my bills, you jeopardizing my job by consistently and continuously sending subpoenas to my job when you could have had access to all of my emails here. And if you know anything about me, Mary, I don't do a lot of emails. You should have pulled the emails of the people who email every day. That's not me. So that was a real problem for me. The other issue that I have is this when they talk about this inappropriate response. And the other issue is, why were you starting to represent yourself? I've never heard of a lawyer who represents himself. Those subpoenas were coming directly from you and not from Mr. Shows. So right, too many lawyers involved. First advice I'll give you, don't ever try to represent yourself. Because I'm sure Mr. Shows probably would have told you not to do it in that fashion. That was an issue. I didn't know who was representing who. The next thing that I have a problem with is, why is this hearing so different from any other personnel hearing that we've done in the past? What makes this so special that some of the same council members have relieved people who had years and years of service and it never came before us, and we allowed them to stay in their lane and do what they felt necessary? Some of the same people who are talking about this is unfair. There were people who were relieved from their duties who had years of service. I guess it was okay when they were doing it, but it's not okay today. That's a real issue for me. And to sit up here and to start calling names of people's children, nobody has ever attacked Mary's family that I know of, and I certainly.
Who called another council member's name?
Don't address me. Don't address me, because if I need to talk to you, I know your name. Or I can just pull up your emails where you talk to Jesus, one of them.
Amen.
Okay. So I think it's unfortunate that we've gotten to this level. I've enjoyed working with Mary but I think that it's now too stressful, everything that has happened, for us to go on. And so that's why today, and I've never met, let me clear this up, I've never met with John Delgado, I've never met with Chandler Luke to remove you, or to this co-conspiracy thing that I've heard that's going around. I've never, ever done that. And in fact, had not made up my mind of what I was going to do until you started subpoenaing me like I was doing something wrong to you and my records. And so I think that this thing has really gotten out of hand, and when you went in and fired, or attempted to fire Leanne Basson, that was out of hand and out of line. And so every little step of this way, it's gotten worse and worse and more out of hand. And I think today's hearing is also out of hand and out of line. Whatever your personal thoughts are about voting for her or against her, you shouldn't bring people's families into it at this hearing. It's unacceptable. I don't know about him, but it's unacceptable for me. So don't try it with me. And I will be voting to remove Mary Roper today.
Mr. Shows, you'll be granted 30 minutes.
decision has been made by at least one council member without even hearing Mary Roper's side. I thought everybody committed at the outset that we were going to have a fair and impartial hearing. And without having Ms. Roper address and making a predetermined decision seems to be not only problematic, but very unfair.
Well, sir, I do have the information in front of me that I reviewed your information and his. And so I've heard both your sides. Based upon what I've heard, unless she says something that totally turns me around, at this point and at this juncture of this hearing, I'm voting to remove her.
But that's one person's opinion again. So again, that we don't, one person can't represent this entire council, and that's all I'm saying. So come on.
And also, we just got this 3 minutes ago. There's no way in the world we got this
Ms.
in
Shields,
this
please
time.
continue.
You reviewed it?
Sean, please.
This is the same information.
Denise, please.
Mr. Loop, I first would like to present some discussion. The memo did not set forth any grounds that you complained of, because it didn't. But that's what the problem is with the process. Everything you mentioned, every single item you mentioned, are not contained in any one of the charges that either Jack Whitehead outlined, that Murphy Foster outlined. How can we address those when nobody put us on notice that that was even a concern of yours? Ms. Roper is going to address each one of the concerns. I'd like everybody just, again, like I said, I want to keep my game plan calm, take a deep breath. Everybody's going to do what they feel is right for the best interest, not of themselves, but for the community. And if we all take a deep breath and do that, then the right decision hopefully will be made. I know that there are some people that I would like to say this. When Mary was elected Parish Attorney, there were 10 new council people, and I understand that. When Trey Welsh is elected judge, or when Buddy Amoroso is elected representative, and let's say that's within the next 4 months, those 2 new council people might say, you know what? I don't like Mr. So-and-so, Miss So-and-so as the parish attorney, and we got 2 new voices to talk about it. So that's why sometimes there has to be consistency with the parish attorney because of the turnover that may take place. So with that said, I'd like to have Ms. Roper address the concerns that she's heard, but likewise, we committed that evidence was going to be presented. I heard Mr. Loop say, I got letters from people, I've got documents from people. He's a lawyer, he says he's a lawyer, and I believe that he is a good lawyer. Where is that evidence? How can I examine that evidence? How can I doubt what you're saying without, like Ms. Roper, Mr. Foster says, she's got to be sworn. She's going to testify. She's got to be sworn. But the glamour of this process is everybody else gets to say, this is what the evidence is, but it's not here. Evidence against Ms. Mary Roper is in this book that you've been presented. And if you've looked at it, tell me where she's done anything wrong in the evidence that's been presented.
Good afternoon. First of all, I would like to say, just briefly, I took a few notes when Tiana was speaking. The matters that were addressed by Chandler, again, as Wade just said, were not anywhere outlined in the grounds stated for my removal. And, you know, accordingly, I'm standing here knowing I do have documents to back up what he was talking about with the bye-bye DWI story with Jim Shannon. All of that was addressed back in 2009. And I explained all of that back then. That had nothing to do with anything that I had done. It was totally misinformed, but I can't stand up here on the fly not having access to documents that I was not prepared to present. So I'm prepared to present documentation. We presented it in reference to all of the charges that were outlined against me and what I was told I was here to defend against, and that's what I'm prepared to do. First of all, I would like to address one statement that was completely inaccurate by Councilmember loop about my husband. He has one software company that he works on from our home on his own time. He does not have 3 software companies. I'm not sure where that's coming from. And then I will get into the software issue. The software issue initially arose, as we all know, when Kyle Jones, an employee of MOSAP, was determined to possibly be doing something inappropriate with the software that had been created by that department. I have no idea what Mr. Jones did. I never had any conversations with Mr. Jones about this software. I have no idea what investigation may be underway concerning Mr. Jones, and I can assure you I have nothing to do with that. Hiller Moore, our district attorney, who I have no reason to doubt would tell you anything inappropriate in the press, has on more than one occasion stated that I have nothing to do with that investigation. I am not being investigated in relation to that software. An email surfaced when they were investigating Kyle Jones in-house that had me sending a copy of the source code, which is the programming language for the software, to my husband. My husband, as I previously explained to you in a memo dated May 12th, in detail regarding the software. He was at the initial meeting regarding the software as a technical advisor because of his extensive computer programming background. He was a welcomed attendee at the meeting. Ms. Morrow was there and she invited and welcomed his presence. He was throughout this process of trying to register the copyright with the U.S. Copyright Office. He was utilized for his expertise. There was nothing inappropriate about me seeking his advice to make sure that it was in the appropriate format for registration. I'm not an intellectual property lawyer, but I did take on the task after the intellectual property lawyer withdrew. And we determined we didn't need to seek a patent, which would have been way too complex for me to do, but we determined we were just going to register the copyright, something that I decided that I would be able to accomplish, and I did. Never received any complaints from Ms. Morrow as to the work that I did. In fact, it was my understanding that she was quite pleased with my performance. And even sent an email after that bragging on, what a wonderful lawyer I am. So I don't know where the allegation is coming from in reference to the diligence in pursuing the copyright. That makes no sense to me. That was a legal endeavor that I undertook for the Mayor's Office of Homeland Security. This was not something that was tasked to me by the council, nor was anyone on the council ever involved. So that is baffling to me. There was a delay, just to tell you briefly, when we had our initial meeting regarding that software. It was in 2008. We engaged the firm of Jones Walker, who withdrew January 23rd, I believe, of 2009. I undertook to finish up the process. It was determined by the intellectual property lawyer that the software was not in an acceptable format for registration because it did not show the programming steps that needed to be showed. And so the programmer had to go back and do that. We've supplied information regarding that. And in our pre-hearing memo, it explained all of that in Exhibit 2 in logos, where I explained he had to go back and fulfill this tedious process. Unfortunately, I'm sure he has other duties for MOSA other than trying to go back and recreate a software that he worked on for years. And it did take him a couple of years to do that. Once they contacted me and said, we are ready to move forward, I moved forward with all diligence, and I sought the assistance from my husband, who I think the city parish is very lucky to have on staff. And it's upsetting to me that anything would be misconstrued by the work that I did on this software registration, which I did completely above board and went, in my opinion, above and beyond the call of duty by registering a software for the city parish, which is not within the purview of even municipal law. But I figured it out to save the city thousands of dollars in doing that. The software itself, just to address, is not proprietary, privileged, secret information. It is a public document. Under the Louisiana Public Records Law, any document created by a public employee with public funds on public time is a public document unless there is a specific exception. There is no specific exception that covers this particular software. The only exception that would exist is if this software contained certain well-defined security features. The definition within the Louisiana Public Records Law sets that forth. I had an independent software company review the software after I received written permission from William Daniel to allow me to do that, just to be on the safe side and make sure no one was alleging again that I showed the software to someone without permission. I did seek and obtain permission from William Daniel, who was over that mayoral department, to do that. After I sought that permission and obtained it, I had an expert review it. He determined that no, there were no security features within that software that would take it out of the realm of being a public document. I spent money out of my pocket to have that done because this was so important to me. I would like to address Councilman Luke's audit, as it has been referred to. This occurred back in 2009, a few months after I first met Mr. Luke, which was actually our first meeting was when he showed up for a meeting in my office shortly after being elected, which was November sometime of the year of 2008, wherein he asked me to step down so that he could get the job to the Springway room. I declined, and after that I was subject to numerous requests by him for information. I was slandered, I was libeled in the press, and after much acrimony, and he tried to remove me back then, we tried to resolve our differences. I went to him and I pleaded with him to please sit down and let's resolve these differences. He did take me up on that, and we sat down in a professional manner. We went through everything that he was claiming was deficient in my office, and we determined that in fact there were no deficiencies, but he had some things that he wanted done, and we agreed to do those things. Those things were put into place and were brought before this council and were, by resolution of this council, which some of you may remember, were adopted back on November 23rd of 2010. There was a resolution number 48332, wherein changes were requested to the city parish's executive leave policy and to the policies and procedures of the Office of the Parish Attorney. I welcomed any oversight by this council if there was something that needed to be done. I said, let's sit down and talk about it, let's do it, and that was the culmination of those discussions. And those procedures have been implemented. Basically what they were, when it came down to it, was he asked that the status of civil litigation files be maintained on our amicus system, which we had been doing for years. We said, of course, we've been doing that for years. We certainly intend to do that. We have no reason not to. The next request was that each attorney be required to turn in a timesheet verifying the minimum number of hours worked. We said we have no problem with that. We've been doing that ever since. The next thing was that each attorney sign a quarterly conflict statement. We implemented that, and we have been doing it to this day. We were also asked that each attorney sign an annual ethics disclosure form, similar to what all of you are required to do. We've also implemented that, and we've done that to this very day. I have had no inquiries by Councilmember Luke since that time saying that somehow we had failed to do what had been asked of us in that resolution. And I don't know why he would think that we haven't, because we certainly have complied.
Mr. Lupa, in accordance with Mr. Murphy Foster's instructions, Ms. Roper was testifying under oath. I'd like her to be sworn. I'd like her to ratify what she just said while she's under oath.
I'm sorry, say that again,
I'd
Will.
like her to be sworn.
Sworn in. Not requiring anybody to be sworn in at this hearing.
Forms are set forth in the procedure. Ms. Roper and her witnesses will be sworn. I'd like her to be sworn.
We'll ask Mr. Foster.
Number one, I can read the procedure that we established or set forth in the August 25th letter, there was nothing about Ms. Roper being sworn.
We need.
I have no problem with Ms. Roper testifying. Sworn or not sworn? I assume she's sworn.
I will swear myself in, if you don't mind. I solemnly swear to tell the truth, the whole truth, and nothing but the truth. And I consider anything that I say previous to any statements going forward to be adopted by me under oath. And anything that I say from this point forward will be under oath. Okay, I would like to address something that was thrown out in the Jack Whitehead book, as I call it, the white binder that all of you have. Some vague allegations that I have a $7.3 million budget and then I have somehow mismanaged that budget. I have not seen any evidence presented that explains how I have mismanaged my budget. In fact, I have always come in either under budget or within the parameters put forth by this administration.
I'm not aware of any allegations about budget issues, Mary.
It was in the binder, so if we can take that out of the binder.
I don't think anybody has any questions about your management of the budget. If you want to address it, you can.
That's fine, I'm just making sure because it was in there, so I just wanted to let you know. I do believe you did make a statement about the budget a few minutes ago.
Okay.
But anyway, I think you said that there was something about it was a lot of responsibility and not sure what the intimation was, but the budget was mentioned. In every year since 2008, and first of all, in 2008, when I first was taken over, that was in budget season, I immediately slashed $150,000 from our budget by combining some positions and streamlining some of our operations. From that point forward, I have done a phenomenal job managing the budget. If you average out every year since I've taken over, we have only increased our budget from 2008 by 0.67%. That should make all of you proud as stewards of the public's money. And I consider myself to be a steward of the public's money, and I take that job very seriously. I'm very fiscally conservative. I do what I can to protect the public fisc, and I think that that's very important. And all of you, I know, want me to do that. I can assume that you want me to protect the public fisc. The issue of the tape recording. When I met with Chandler, I had been summoned to his office. I was not allowed to know what it was about. I was told to come there by myself, basically. This was on the heels of a prior meeting where I had been similarly summoned on March 20th, where I had been fussed at by Mr. Loop for not hiring Greg Rome in a position that he felt he was entitled to be hired in. And for Mr. Loop, I was not filling that position, and that I had offered Mr. Rome a position in the prosecutor's office. Apparently, Mr. Rome decided the position in the prosecutor's office was not to his liking, and therefore I was hauled in and fussed at. This meeting, where I was similarly summoned, caused me great concern. Great concern. I thought that Chandler and I had put all of the acrimony behind us, and I was trying my best to give Mr. Rome a job because Mr. Luke kept insisting that anytime a position came open, you know how I feel about Greg, and I was trying to extend an act of goodwill by offering him that position, and I felt that it was suited to him, as he is an assistant public defender, and I felt he had an acumen for criminal law, and that would be a good fit for him. Instead, he wanted a different job, apparently, and so I displeased Mr. Luke, and I got fussed at. So I'm summoned to his office April 28th under very similar circumstances where I'm not told, I need you to come down here for such and such. I need your advice on something. I had my guard up. With the history of Mr. Luke, I was very scared for my future in my position in the Parish Attorney's office. So, I took the prophylactic measure grabbing my cell phone on my way there, and I hit record. Had this been a meeting where he was seeking my legal advice, I would have immediately deleted it. Instead, no. This was not a meeting where he was seeking my legal advice. This was a meeting where he was telling me I was being criminally investigated, that my husband was being criminally investigated, that my husband had been put on leave, which had never happened, that I needed to seek a criminal defense attorney's advice immediately. It was very intimidating. It was very frightening. I've never been accused of a crime before. Certainly not by someone that I work for. It was extremely unsettling, as you can imagine. I was shaking. I tried to defend myself. He said, I don't want to hear it. Don't tell me anything because I might get a subpoena. I said, okay, I have nothing to hide. I want to tell you. I can assure you, I have done nothing wrong relative to any software program. I would like to explain that to you. I would like the opportunity to do that. He didn't want me to. Instead, he informed me that people on my staff already knew about this and that the council wanted me to go on leave. It was very disturbing. So I kept that recording for my own protection. The recording had nothing to do with Mr. Luke seeking legal advice from me, which would make it a confidential communication between a lawyer and the client. Mr. Luke is not my client. He is a representative of the city parish, and as such, I respond to him. The city parish is my client. The council as a whole is my client, and he is a representative of that. Had he been seeking legal advice, it would have been confidential. That was not the case. I have never threatened to release that information. I don't know what he's talking about, saying that I have threatened to release that information. I would like to be shown any instance where I have threatened to do that. We have asked him to authenticate portions of it that were just sent directly to him. I have not been playing the tape for people, as he alleges. This was...
Where's the tape, ma'am? Where's the tape?
The tape is in the possession of Mr. Shows, as per agreement between Mr. Luke and myself. It's being held by him in case I need it. I do not have a copy of the tape. I gave the copy to Mr. Shows as per agreement with Mr. Luke. And I will tell you, one thing in the tape, since we are at this juncture, I do have to protect myself. I do have to defend myself. He admitted that what he had done to me back in 2009 and 2010 was unwarranted, and there was no excuse for that. And now I'm a changed man. He made those statements to me.
Did you say he apologized to you for something?
He did.
What did he say?
He said, I apologize for putting you through that. I know it was wrong. But now he sits up here today and re-urges those same things. I don't even know what to believe anymore. I was also told in that meeting that, Mary, if it turns out you've done nothing wrong with the software, I'll be the first one to issue a public apology to you. I'll do whatever you want. He made those statements. I've since been told by him that he knows I didn't do anything wrong with the software. I'm still waiting on my apology, but I know I'm not going to get it. I've been told by everyone that I've spoken to that was willing to speak to me about the software issue after it happened, that, we realize you didn't do anything wrong with the software, but it still showed up in the grounds to remove me. I don't understand that. And the issue with the lawsuit, this was out of necessity to state the proper procedure to have a hearing so that I would be able to present things in a fair manner and I would have a fair opportunity to defend myself. I've worked for the city parish in my 21st year. I've had an impeccable career. I've always been responsive. I've never had an issue of a disciplinary nature. I've never had any issue where I was called in by my boss for doing something inappropriate or improper. All of this began in 2009, or late 2008, I should say. It was my first meeting with Mr. Luke. I did not sue all of you to do something to you. The reason for the suit was that was the appropriate procedure under the law to seek clarification from the court. And that was the way it had to be done. As far as subpoenas being issued and public records requests, the public records requests, I didn't understand were a part of this meeting, but I can assure you as well, conversations that are had between public officials, regardless of what means of communication, are public documents, and therefore those had to be sent in the manner that they had to be sent. It was not for any reason to harass anyone or upset anyone. It was just being done in accordance with what the law requires. So I apologize if I have to go through the legal process that way to get a fair hearing, and I am sorry if I offended anyone. That was certainly not my intent. I want to briefly address the dual office holding issue that was raised against me. This is a contract position that I have with the Louisiana Appellate Project. It is a nonprofit that represents indigent defendants who've been convicted of a crime that cannot afford to hire someone to represent them. My job is to make sure that constitutional guarantees were in place and that they received a fair process, which is all I'm asking from each of you today, that I be given the due process rights that I'm due under the Constitution of Louisiana and the federal Constitution, and that I be provided a fair hearing and not have allegations thrown at me on the fly that have not been told to me were going to be a subject of this meeting today. This has been devastating to me personally and to my family. A couple of weeks after this was in the news, my little girl, who I thought knew nothing about this, she's 8, burst into tears and said, "Mommy, are you and Daddy going to jail?" It was heartbreaking. Heartbreaking. I had to assure her, after I got her to calm down, she was crying uncontrollably, that no, Mommy's not going to jail, Daddy's not going to jail. We didn't do anything wrong. Some people are saying certain things, but we didn't do those things, and you don't need to worry about that. And I have tried since then. It's been so public. It's been horrifying to me to try to shield her from that, and to try to shield my mother from that, who all of you know was diagnosed with cancer during the midst of all this. Somehow this information got to my hometown, and people started saying to my mother, "I hope Mary's okay with all of this." She didn't know what they were talking about. I tried not to tell her because she had too much going on, but I had to eventually. This has been killing me and my family. This is horrendous. I have 21 years in the system. I had hoped to get to 25 years so I could draw my retirement at full benefits when it's calculated at 3%. I would be able to get 75% of my top 3 years if I made it to 25 years.
What risk are you taking by having this hearing?
I'm having to put all of that at risk. If I'm forced to leave today, I will draw only 38%, as opposed to 75% after 21 years. Thank you. In conclusion, I would just say that I would hope that you would base your decision on the evidence that was presented to you and not spurious allegations where there has been no evidence given to you, and that you would consider the whole body of my career with the Parish Attorney's Office, from the point of being a law clerk, working my way up the ranks, and working as a city prosecutor, working as the council legislative section chief, where I worked very closely with council members. Had I had any imperfections or deficiencies in my performance, surely those would have been brought forth, and Mr. Shows, coming in as a new parish attorney, would not have decided I was the one to put as his first assistant. Thank you.
Thank you, Mary. Marking, that's 30 minutes right there.
Okay, 18 seconds, that's 30 seconds. Stop.
Archie?
And so, Mr. Show says, the council sued all the time. The council sued every week. I dare say this is the first time in history that their existing attorney has sued them. Clients are not sued by their attorneys, asking to remain their attorneys all the time. It doesn't happen. She suggests that you, and you, and you, and you, and you're not her clients. It's incorrect. Code of Professional Responsibility for lawyers say that they have special rules for organizational clients, which you are as Metro Council. Organizational clients can only be and act and exist through individual representatives as you. When one of your conversations is it's like taking her client because you are her client. She doesn't think it's a problem to subpoena you because you're not her client. No, you are her client. She subpoenaed individuals of you. She subpoenaed you for deposition testimony, a number of you. She subpoenaed a number of your personal email accounts, seeking your personal information from those email accounts and how it might help her in her case. Lawyers are not allowed to take conflicting positions against their clients of that nature. You are her client. She is your lawyer until you say otherwise. She doesn't believe that the source code for most software was a problem to get at because she believes it was a public record. She is wrong. There are a number of cases that say otherwise. I read to you verbatim out of our public records law the specific exception for source codes to software that say it is not a public record. She doesn't believe that it's wrong to clandestinely tape her client. We choose to disagree. She didn't think that she was an at-will employee. Judge Caldwell disagreed. She sued you. That lawsuit has been dismissed. She is at will. She serves at your pleasure, just like any attorney serves at the will and the pleasure of their client. Thank you.
Wait.
I'd like to call for the remaining amount of time I have Brian Rigsby with NBOT.
You have 3 minutes.
Good afternoon, ladies and gentlemen. My name is Brian Rigsby.
Your sensitive to be a witness on the time and so on.
Swear him in.
Some swear testimony about to give the truth, the whole truth, and nothing but the truth. Please state your full name and position.
My name is Brian Rigsby. I am the Technical Development Manager at Invoke. It's a software development company in Rio Grande Rouge. I've been in that position for 4 years.
Were you retained by Mr. Roper and rendered an opinion regarding this issue that we heard over the Mosaic software?
Yes.
Wait, you're going to have to stand for the mic.
And as such, are you familiar with the issue as to whether the furnishing of the information somehow was a violation of security for the parent?
Yes.
And tell the council, if you would, what did you review, what's your conclusion?
So we might first need to talk, if you guys would like to know a little more about what the source code is, what we were given.
Sure.
What I was given was actually a source code, but the application that I think is in question here has nothing whatever to do with that particular code. And there's certainly nothing, at least as what we would define proprietary from a software perspective, in any of that code. That would be something that would be a specific type of algorithm, business logic, or validation type rules, or those things that had anything to do with the actual business itself. None of that is contained within any of that source code. Further, with the question of anything that is based on security, there's certainly nothing involved, nothing in the source code that has to do with that. And that would include things like passwords, usernames, logins, log out, administration of any kind. None of that is contained within the specific source code that I was given.
Thank you. That 3 minutes includes my close?
Yes, sir.
Mr. Foster delivered an eloquent closing, handwritten. He knew exactly what he was going to say. He wanted to incite your prejudice. You got sued. You got subpoenaed. Well, you know what? If you'd have had this hearing when we asked to have the appropriate procedure, nobody had been sued. Nobody had been subpoenaed. She was backed in a corner, not knowing exactly what the procedure was going to be. So you know what she did? She did not take it to the street. She took it the way our kids are supposed to be taught to resolve issues in the court system. Boys counsel back here, that's the way disputes are supposed to be resolved in the court system. It is a tremendous hill for Ms. Roper to overcome. After 8 months, 6 months, since 2008, people have had agendas, maybe, some people. She has lost other supporters, maybe, because of lawsuits or personal issues. So today, 30 minutes, we're going to decide 21 years of impeccable service. I may have lost you, Mr. Hack. I may have lost Mr. Delgado, my friend, Mr. Lou. I know I've lost him. Mr. Amoroso, I hope that you consider the evidence and also the other people, the evidence. Not argument from quality lawyers, the evidence. Sworn testimony is what I understand evidence to be. I never saw one person raise their hand except Ms. Roper. Please don't do this. It's not right for her, and it's not right for the community. We can always revisit it if we have Mr. Amoroso, Mr. Welsh, that are no longer with us. You're going to have to continuously revisit. Don't do this. It's an institution. It really is. Thank you.
Thank you, Wade. This time I call for the question. The motion on the floor is a substitute motion by Councilwoman Wicker. We'll vote on that first. If you would open the machine, please, to delete the item. Is that correct, Council?
Begin voting on the motion to delete.
Motion has failed. The next motion is to remove Ms. Roper as Parish Attorney. If you would please open the machine.
The machines are open.
Motion is carried. Motion to adjourn by the chair, second by Delgado. Meeting is adjourned.